We have a tendency to go right in and to assume people who are assuming jurisdiction have a jurisdiction in the matter and or the person, and we give them jurisdiction. Then we start arguing issues of trying to get out of certain situations when they never had it in the first place that you give it to them.
And here we have Taj making a pure sovereign citizen argument, namely that he and by extension other Moors are not subject to government United States jurisdiction. And as I explained to a commenter the other day, that belief is what makes you a sovereign citizen. If you believe that the United States has no jurisdiction over you, that makes you a sovereign citizen. The same way that if you believe in Jesus, that makes you a Christian. Your beliefs are what make you a sovereign citizen. As an example, I'm going to read from a 1983 case about Richard D. Roller. He was another sovereign citizen who in 1983 argued that federal courts have no, quote, jurisdiction over a sovereign citizen. This was thrown out. He lost the case, blah, blah. But I bring it up because this is the stuff that these guys bring up. And Taj also refers to a fundamental misunderstanding of what jurisdiction is in this clip. He claims that jurisdiction is something that the individual gives to the state. Unfortunately, that is not how jurisdiction works. To discuss why that's not how it works, I'm going to read from Penayer v. Neff, which is an 1878 Supreme Court case, which I've read before, but it's a very good explanation of how jurisdiction works in this country. Quote, and that they are sound would seem to follow from two well-established principles of public law respecting the jurisdiction of an independent state over persons and property. Except as constrained and limited by that instrument, quote, the Constitution, they possess and exercise the authority of independent states, and the principles of public law to which we have referred are applicable to them. One of these principles is that every state possesses exclusive jurisdiction and sovereignty over persons and property within its territory. As a consequence, every state has a power to determine for itself the civil status and capacities of its inhabitants, to prescribe the subjects upon which they may contract, the form and solemnities with which their contracts shall be executed, the rights and obligations arising from them, and the mode in which their validity shall be determined and their obligations enforced, and also to regulate the manner and conditions upon which property situated within such territory, both personal and real, may be acquired, enjoyed, and transferred. This is a basic principle of law. States have jurisdiction over everybody within their territory. That is the entire purpose of a state. If you deny that concept, that is what makes you a sovereign citizen. Texas has jurisdiction over everybody within the landmass that is within the borders of Texas. Everybody in Nebraska is subject to Nebraska jurisdiction if they are on within the borders of Nebraska. That is how law works in this country.
If I make a claim on you or against you, what you should be arguing to me is not necessarily the substance of the matter.
Well, this is just horrible advice right there. The substance of the matter is what you need to talk about. If you're being charged with murder, you need to say that you didn't murder anyone.
When what you should be arguing is not that, but number one, where did I derive my authority and enter it into the record? That's number one.
This is one of those comments that makes you wonder what the hell Taj is thinking, because for one thing, this is a moot point to bring up. It does you no good to go into a government court to argue that the government has no authority. And secondly, what exactly is Taj expecting to happen? I believe Taj is currently in New York. So does Taj expect the court or the judge or the prosecutor to go down the line, explain to him, oh, well, in 1977, New York wrote a constitution, and then a few years later, the legislature wrote a law, and then the government signed it into law, and that created the court, and then they wrote a law, and that gave us jurisdiction to charge you with this. No touch. They are not going to give you a history and civics lesson explaining to you how the state of New York has authority to charge you with a crime. That is not how it works. They're not required to do that. If you want to learn where they got their authority from. Go buy a book, go to a library, and educate yourself. They're not there to teach you history and civics.
Because before I can claim a right or an authority over you, the only way that your birthright can be given to me in any sovereign capacity, if you're in agreement with me through your parents or through some organized system government prior to me, that which I'm by bloodline obligated to.
Well, number one, that's not how it works. You do not have to be part of a specific bloodline for the government to have jurisdiction over you. But number two, this just shows how racist Taj's ideology and the Moorish ideology is. The argument that because they're from Moorish bloodline, therefore the government doesn't have jurisdiction over them is entirely racist. But it's also ironic because it's actually the inverse argument that the white supremacist sovereign citizens make. The white guys argue that the government only has jurisdiction over black people, and the black guys are arguing that the government only has jurisdiction over white people. Of course, they're both wrong. The government has jurisdiction over both of them.
You're the law.
No, you're not. You're not the law. What Taj is describing here, where every individual gets to pick what laws he follows, is anarchy, the exact opposite of a republic.
And if I impose that on you, then I'm maintaining slavery, which is a violation of civilization.
I love this line because it's 180 degrees the opposite of the truth. Being subject to the laws of the country you live in is what civilization is about. It is not slavery.
Which gives you a right to take that person's head, really. And any other civilized person has the right and authority in assisting you in international law to take that person's head.
Yep, that's Taj advocating violence against government officials and law enforcement officers.
Well, if you're making a claim, introduce it into the evidence before people of my own national peers.
Let's keep in mind that by national peers, Taj is referring to other Moorish Americans, which is why the Moorish movement is categorized as a black separatist, black nationalist movement. This is not how it works in this country, Taj. If I get charged with a crime and there's a jury trial, I might have white people on the jury, I might have Latinos in the jury, I might have black people in the jury. It doesn't matter because they're all my peers.
And basically, the stuff is it's very, very simple once you have certain fundamental component parts. So you have to understand right? Then you have now in issues of controversy, that's the process.
Now, if you can't read the whiteboard, what he wrote is status, jurisdiction / venue, and adjudication. Now, I tried to look this up to see where he got this from, and as far as I can tell, the only place where this applies is in divorce cases in which the husband is in one state and the wife is in another state. So I'm guessing he got this from some law library, reading a book on divorce law, and he's somehow expanded it to include criminal cases. But what's fascinating is that in addition to divorce cases, the other thing that shows up if you search for status, jurisdiction, and adjudication is other Moors who have tried Taj's status and adjudication argument in court unsuccessfully. The first one that shows up is Rippey Bay v. North Carolina, in which he put in a legal notice proclamation of status and jurisdiction where he proclaims that he's a Moor, which of course was thrown out as ridiculous, and his appeal was denied. Worth noting that this guy was in jail in 2014. I'm guessing he's still in jail right now. I could probably look that up now. And oh boy, I have struck gold. Here we go. Charles A. Rippey Bay v. State of North Carolina, June 8, 2016. Open quote. On September 27th, 1993, petitioner pleaded guilty in Catawba County Superior Court to first-degree sex offense. The Superior Court then sentenced petitioner, a juvenile offender, to life imprisonment with the possibility of parole. So that's just great. This is a convicted rapist in jail for life, trying Tarik Bey's legal strategies from inside jail, trying to get out. Bravo, Taj. Now, the second case I was able to find of somebody using Taj's status and jurisdiction argument is Harvey v. Jefferson County Detention Facility from 2012. Quote, Stephen L. Harvey is a prisoner currently incarcerated at the blah blah. Let's see here. Mr. Harvey asserts proclaim proper status and jurisdiction Murunia American Nation al Azab al Safat. How the word blah blah. Mr. Harvey apparently asserts that the trial court lacks jurisdiction to convict him because of his status as a Murunia American nation. The court's response is, in this case, the fact that Mr. Harvey has labeled himself as a Murunia American nation does not change him from a human, natural person to a legal entity, thereby depriving the state court of jurisdiction to prosecute him for criminal offenses. Quote, jurisdiction is a matter of law, statute, and constitution, not a child's game wherein one's power is magnified or diminished by the display of some magic talisman or by the use of special seals or apostilles on documents or by the recital of special words, phrases, or arcane incantations, whether capitalized in written text or not. Therefore, the court finds that Mr. Harvey's allegation that the state court lacked jurisdiction to prosecute him because he is a Murunia American nation is factually frivolous because the argument is wholly incredible. Now, I was not able to find out why Harvey was or is in jail for, because the state of Colorado wants to charge me $7 to look that up. So if somebody wants to figure out why he's in jail, feel free. But it seems that while he was in jail, he started getting a lot crazier over time. In another lawsuit, he wrote his name as Stephen L. Harvey, impropria persona sui juris, Imam Abdullah al-Rashid al-Mam Muhammad M. Abdullah A.E. / al-Mam E / al-Rashid Dul Habid al-Rashid al-Hakka al-Azab Vicegerents, Sheikh of the Murunia American Nation, al-Azab al-Safat applicants. Now, the final case, which I'm going to read, in which a guy tried Taj's stuff in court and failed, is Walter D. Hedden L. Now, remember, the L suffix is typical of Moorish Americans. Now, for context, Mr. Hedden is currently in jail for sexual offense of a first degree with child. Yes, this is a guy that raped a little kid, which is a little bit of a disturbing pattern that of the first three cases that I was able to find of people trying Taj's stuff in court, two of them are sex offenders. Anyways, Hedden sent in a petition saying that proper status and jurisdiction was not established before any legal proceedings. Again, Hedden got the idea that status and jurisdiction needs to be established from Taj, which again Taj made up. And anyways, it goes on to say, the supporting facts read in their entirety. I, Walter D. Hedden L., am a Moorish American national, impropria persona, and am therefore a sovereign aboriginal inhabitant of the Great Seal continental U.S. Federal Republic, under federal, not ex post facto color of law, state government jurisdiction. I was prosecuted under the misnomered racial slave status as black, for which one is counted as 3/5 of a person / property of the state, under Article 1 and the 14th Amendment of the U.S. Constitution, ineligible for certain rights. As an indigenous person of the continental U.S., I am entitled to all the rights and protections under the U.S. Constitution, Treaty, and 61295 United Nations Declaration on Rights of Indigenous People. Now, this is great judgment because it goes into the details of the sovereign citizen Moorish American ideology. Quote, Exhibit A to the petition consists mainly of a declaration and proclamation of the Moorish American nation, an affirmation of jurisdiction by the Moorish American nation, a Moorish American birthright of independence, and a divine constitution of Moorish America. It asserts that the latter is dissolving the political bands and assumable jurisdiction of the former. It claims that the Moorish Americans are descendants of the Moroccans from the old Moorish Empire, whose ancient forefathers received permission from the pharaohs of Egypt to settle and inhabit northwest Africa. The settlement resulted in an empire that stretched across north and west, southwest Africa, extending across the Atlantis, even unto North, Central, and South America, also Mexico and Atlantis Islands, before the great earthquake which caused the great Atlantic Ocean. Based on this view of history, the Declaration, Proclamation, and other documents state that the Moorish Americans wish to withdraw from the jurisdiction of the United States and to establish their own separate nation on this continent. They reject slave labels, such as Negro, and challenge the jurisdiction of the United States. He submitted transcripts of plea and judgment. They show that he pled guilty to multiple offenses and received a single sentence of 144 to 182 months. And then there's a note. The note says, 1. A search of North Carolina prison records reveal that the prisoner is incarcerated for convictions related to the sexual abuse of one or more children. And here we got to a discussion of the argument. Reduced to its essence, petitioners claim that he is Moorish American and that based on his ancestry, the state of North Carolina does not have jurisdiction to prosecute him or imprison him for committing sexual offenses against a child or children. There is no basis in the law for such a claim. The fact that a group claiming to be Moorish Americans has written documents that might support this idea, or that the documents were delivered to a former president, does not establish a valid claim. Moreover, petitioner is not the first person to raise this or similar claims based on an alleged status as a Moorish American. These claims have been rejected. See Pitt Bay, Albert Fitzgerald, and it gives a bunch of cases where other people have tried this. The court is aware of no instance where such a claim has succeeded or even been recognized as potentially viable, because it does plainly appear from the petition and attached exhibits that petitioner is not entitled to any relief. And that was in 2011. He is still in jail. So in summary, the status and jurisdiction argument which Taj promotes in this video is false. It has been tried by multiple people. Quite a few of those people are in jail because the argument does not work, period.